Breach of contract and remedies is what we're going to cover next. What is the breach of contract? Breach of contract is the failure to perform in the manner called for by the contract. What is the effect of the breach of contract or breach of contract? When one party breaches the contract, the other party, the non-breaching party, has the right to a remedy in court. Anticipatory breach and ordinary breach are not the same. An ordinary breach occurs at the time for performance, whereas anticipatory breach occurs when a party to a contract either expressly or clearly implies an intention not to perform the contract even before being required to act. So the breach occurs before the time for performance. When a party expressly declares that performance will not be made, this declaration is called an anticipatory repudiation or breach. It must be a clear, absolute, and unequivocal refusal to perform the contract according to its terms. It can include refusing to perform the contract before the time for performance unless the other party does an act that was not required under the contract. Anticipatory breach. The injured party may either commence suit at the time of the anticipatory breach or wait the date agreed to for performance, thereby giving the breaching party time to reconsider and begin performance. The injured party may also accept the repudiation as an offer to cancel the contract. A party may take back an anticipatory repudiation as long as the other party has not changed position in reliance on the repudiation. Waiver of breach. Under certain circumstances, a non-breaching party may be willing to relinquish the right to object to breach of contract or ignore the breach. This action is called a waiver of the breach of contract. Consequences of a waiver of a breach of contract. When a waiver of a breach of contract occurs, the party waiving the breach cannot take later action on the breach. The waiver of a breach of contract extends only to the matter waived and not the whole contract. An aggrieved party may accept a defective performance cure without thereby waiving a claim for breach if the party makes a reservation of rights. Remedies for breach of contract. One or more remedies may be available to the innocent or non-breaching party in the case of the breach of contract. A remedy is the relief provided for an innocent party when the other party has breached the contract or damages. The most common remedies available to a non-breaching party include monetary damages, rescission and restitution, specific performance, reformation, and injunctive relief, all of which, except for monetary damages, are equitable damages or remedies. The types of monetary damages. Monetary damages can include compensatory damages, consequential damages, punitive damages, and nominal damages. Compensatory damages compensate an injured party for damages actually sustained by the party or the actual loss. The non-breaching party must prove that the actual damages arose directly from the loss of the bargain caused by the breach. Incidental damages are expenses that are caused directly by a breach of contract, such as those incurred to obtain performance from another source. Special or consequential damages. These are the type of damages that are foreseeable damages that compensate you for a loss that is not a direct or immediate as a result of the breach of contract. So an example is a seller fails to deliver goods and the seller knows that the buyer is planning to resell these goods immediately. Special damages may be awarded for the loss of profit from the planned resale. Punitive damages are designed to punish a wrongdoer and set an example to deter similar conduct in the future. Nominal damages are damages that are awarded to an innocent party when only a technical injury is involved and no actual damage or financial loss has occurred. An example will be an award of $1. In most situations, when a breach of contract occurs, the innocent party is held to a duty to mitigate or reduce the damages he or she suffers. Equitable remedies or damages, rescission and restitution, specific performance, and reformation. Rescission and restitution is the failure of one party to perform under a contract which entitles the other party to rescind or cancel the contract. The rescinding party must give proper notice to the breaching party. The purpose is to restore the injured party to the position occupied before the contract was made. Each party must make restitution to the other by returning goods, property, or money previously conveyed. Reformation. When the parties have imperfectly expressed their agreement in writing, the equitable remedy of reformation allows the contract to be rewritten to reflect the party's true intention. Look for fraud or mistake. Specific performance. This is an equitable remedy that calls for the performance of the act promised in the contract. So you're asking the court to make the other party or the breaching party perform. With the sale of land, the court will order specific performance because no piece of property looks alike, assuming that there is a breach of contract. For personal property, specific performance is only allowed when the personal property is rare, unique, custom, of an unusual age, beauty, history, or distinction, something you can't find somewhere else. And the court will not order specific performance for personal service contracts. It's too close to slavery. Contract provisions that affect the remedies and damages. Parties may provide for a liquidated damages clause where they speak to in the contract what the damages will be. This is allowed if it's difficult or impossible to determine actual damages, and the amount specified must not be excessive when compared to the probable damages that would be sustained. An exculpatory clause provides that a party may not be liable for damages in the case of a breach of contract and are considered to be valid contractual terms.